The United Kingdom passed their first law dealing with bribery in 1889, and as time went on, they passed several other acts also dealing with bribery. As the country became more globalized, the UK realized that their acts were unsuitable for complying with international anti-corruption agreements. An additional Bribery Act was introduced in 2009 and became the Bribery Act of 2010, which took effect in 2011. This act does not allow any form of bribery and considers both the offering of a bribe and the accepting of a bribe as general offenses. The Bribery Act places full liability on companies for not detecting bribery. This includes both companies operating in the UK and UK companies operating abroad. Penalties can range from a maximum of 10 years in prison to unlimited fines to confiscation of property. The Foreign Corruption Practices Act and the Bribery Act have many similarities, however, there are significant differences between the two, including that the Bribery Act is seen as more encompassing. An additional difference is that the Foreign Corruption Practices Act allows for facilitation payments, whereas the Bribery Act does not. Furthermore, the Foreign Corruption Practices Act is specifically focused on bribery with foreign or government officials, whereas the Bribery Act focuses on those officials as well as private or public officials or enterprises. Liability is another area of difference between the two, where under the Foreign Corruption Practices Act, a company has strict liability for bribery as it relates to accounting provisions for public companies. On the other hand, under the Bribery Act, strict liability applies to any commercial firm that does not have adequate controls for preventing bribery.